You're listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony and Cheryl. Tony and I are here every Tuesday from 12 to 1 p.m. on irlonestar.com or 104.5 or 106.1 Conroe's FM. And we are here. We're two licensed Texas attorneys, and we're here to answer your legal questions, address legal situations that you may be facing, and just kind of help you through a maze that is overwhelming and confusing to so many people. And so, some people can't afford to get an attorney to answer just some basic questions.
Mm-hmm. Thank goodness for the internet.
Yeah, no kidding. But we want to provide that service for them too.
Yes.
For our listeners.
Well, I mean, even when we look at the internet and use our legal research engines,
Right.
it can just be a conundrum of confusion. So always good to help.
Right. And so today, Tony and I are going to talk about wrongful termination in Texas.
Employment. We have this. The two of us have been getting just an overload of calls on employment issues. I know
Right.
you have because we were talking about it.
Right.
And it kind of goes in waves. Sometimes we get nothing but DWIs.
I know.
And
Isn't
then
that true?
sometimes we get nothing but homeowners associations or land issues. People are squabbling about their land and their land title.
Many
what have you.
DWIs are around the holidays.
I haven't found that there's any really one reason or not, but for
No.
whatever reason, this week I've gotten emails and texts and
Mhm.
calls
Mhm.
on a broad array of employment issues. From non-competes to discrimination to just being hired and wanting to know what their contracts are,
Mhm.
or if they even have one and that kind of thing.
Mhm.
So that's why today we're doing employment.
Yeah. I got a call just a couple of weeks ago, maybe 3 weeks ago, from a man that had been with a trucking company for many years. And the trucking company kept trying to give him rigs that were not compliant with the safety laws of the highways and stuff.
Mhm.
And so he would refuse the rigs.
Mhm.
And then he started getting his own rigs. And the guy was also sick.
Uh-oh.
So they just terminated him. And
Mm.
it was right at the time that he was asking for, there's some sort of a disability that's accelerated. It's like
Oh.
a
Mhm.
special.
I usually like cases like that because when they get terminated when they've actually done something, they haven't done anything wrong, which we're going to talk about today. So there's no other reason, and they're not laying other people off. But if they've asked for something that is a little bit over
Right.
what they're willing to give them, and they've made a little bit of noise, and they may be like a
Yeah,
whistleblower,
exactly.
then I like those cases, and I've done them before, and they end up in
Mhm.
federal court, and they're good. But just like you, I've been getting just the whole spectrum of
Right.
thing. People I was fired because I was pregnant. I'm older. They're promoting other people beyond me. They're harassing me.
Right.
I just took this job and they're not giving me what they said they were going to pay me all of a sudden. I mean, just the whole gambit
And
of
a sign a
employment issues.
non-complete compete. And so now what am I going to do? Because I'm not even
Yeah,
in
I
the
can't even
position-
leave. They got me
Yeah.
to sign it. They duped me into coming here, and now
Right.
I can't do it. So
Right.
we have. Hopefully, we'll cover.
Answer some of those
We'll be able to
questions
cover
today.
sort of how employment law works in Texas.
Okay.
And what where you can go to, what you need to do if you feel like you fall into a category where you may need some compensation or even workman's comp because you've been done wrong.
Right. Okay. So first of all, Texas is an at-will state.
Yes.
So at-will means that you're working at your own will for whoever you're working for, and your employer has employed you at their
will.
own will.
Right. So
Right.
it's totally at will. Both
It's at
ways.
will.
And we know that Texas is very much an employer state, not an employee state.
Right. And it also, because we're at will, it means that you can be terminated at any time for anything.
For any reason. You're wearing a pink tie, and I
Yeah.
don't like pink ties.
And you can also quit at any time for any reason.
Right.
But as Tony just alluded, that really goes in favor of the employer, not the
Right.
employee.
Right. Mhm.
Right. Okay. So Texas is at will. We want to start with that. And so our first topic is wrongful termination based on breach of contract. So first of all, we're at will.
And then I'm just going to just stop for 1 second, just because this is how I remembered employment law when I was in law school, and I applied the exact same sort of visual structure when I did employment cases out of law school, and you just kind of have to think of it like a triangle. You've got basically you're either at will with no contract, or you have a contract, and under that contract, there's certain things that you now have more rights because they can only fire you for a cause, perhaps, or there's certain other things that you look at. But you're at will, and anything goes, or your contract on the other prong, or there's a whole different prong, and that's discriminatory reasons. So you have to look at that too. When and also when you look at contracts, that kind of falls under the employee manual falls under that gambit of employee contracts. So you may have a contract and you didn't even know it because they follow rules in their manual that are listed in there, and it may actually say in the manual that you can only be fired for cause. So that being said, if our listeners have sort of a visual image of how it works.
Mm-hmm. I like that. And we were talking about that earlier, and I was hoping that you would say that. So you've got the at will with no contract. You've got the contract, and that can either be a contract that you sign, or it can be an employee manual that you sign different pages in.
And it can also be an oral statement. That's a contract too, not just a written contract. But those are so hard to prove. So what I tell people that are getting new jobs and they're really skeptical, so they're leaving another one, they're leaving something behind to take this, is just to have your phone going and record it, because that's proof.
Yeah, yeah. And then on the other prong, you've got the
In
discriminatory
your pocket,
reason.
because you don't want your new employer to think you're recording everything they're saying. And as long as you're not an attorney, you can do that without telling them.
Yeah, but attorneys have to tell them, I've got you on record here.
Mm-hmm.
Yeah. Okay, so now we have at will. Now we've got wrongful termination based on breach of contract. And as we'd said, contract is something you signed, something you're orally told, much harder to prove. I would rely on what you signed. And that can be found also the employee manual. I've had businesses where I had 40 employees and created these employee manuals and know how binding they are.
The bigger companies have them because it's so structured, and the employee manuals actually protect the big businesses. So they like to have here at section 2(1)(a), you've not complied with this, and that gives them a reason to fire you. So you have to look at those really closely. But a lot of times I love employee manuals. I think they backfire because when you look at the employee manual, a lot of times it gives you it's supposed to look like it's all cherry and rosy and everything's wonderful. And the reality is it locks them into a box on what they can get you for. And the truth of the matter is you want to be happy where you're working. It's the big part of your life every day.
Right.
And if you're not happy where you're working, then your life is going to be pretty miserable.
No kidding.
So and I think we talked about this on previous shows. If you just started a new job and you're not happy, just don't think about suing. Just get out and find another job, because it's just not a good fit.
It's right.
It's not worth suing over.
Okay, so to prove, you guys need to think about these elements, okay? So if you signed a contract, or you've been given an employee manual and you signed stuff in it, or some sort of oral promise, or this for that, tit for tat, whatever they've told you, you need to prove that an employment contract existed, the employee satisfied their duties under the employment contract, the employee was fired due to circumstances that breached the terms of the employment contract, and one more, damages. Damages were caused by breach of the employment.
And that's a big one for people that just take a new job, because if they left a job and they had a certain salary, and then they went to go take the new job, and what are the damages if it's only they get duped because they walk in and for a car salesman, for an example, they're not going to get the commission they were promised, or they backpedal because they were just really trying to steal you away from the other place because you were doing so well. Whatever the case may be, you go over there and now they've reneged on it. You've worked there for, say, a month, and now you've sold all these cars, and they're not going to give you your commission on it, or they've changed something. Then the damages are really difficult because the previous place was so much lower. Then what is the damage when you compare it to what you had before to what you had now? Because you were making less before.
Right. So a promise, if you come over to our car dealership and we're going to, our employees, our salesmen make $3,000
We're going to give
month.
you this much more per month. We're going to give you $3,000 a month flat per month. You don't have to sell any cars.
Right.
And we're going to give you, this percentage or this flat rate for each car you sell. And at the other place, you weren't getting that. So but you were doing well. You were still doing pretty well.
Right.
And you go over and they completely dupe you. Then what are your damages? Because you have to compare it to what you were making before. And if you don't have if you don't have a written contract, let's say it just didn't get signed yet, And these people are good. I mean, I worked for several people before myself that just didn't like to sign anything. They were small entrepreneurs and they wouldn't sign anything. I'm surprised they signed a check. They just wouldn't put their name on anything. They were so afraid of being sued. So then you had to rely on oral contracts, and everything was just, they were just paranoid. They made a lot of money. They were like crazy rich people. But anyway, the bottom line is, yes, that's a really difficult, that fourth prong of proving damages were caused is a difficult one to prove.
Well, and not only that, Tony, but people have a duty to mitigate their damages. I mean, like what I want our listeners to understand if they're facing this is if you feel like you've been wrongfully terminated, you can't sit at home and complain for 6 months.
Yes,
You've got a duty to go out and look for another job.
right.
And so, like Tony just explained, whether you make more or less at that new job, or whether they keep their end of the deal or they don't at that new job, you still have a duty to go out.
Well, you have a duty because you got to pay your bills, and it's really most people want to rely on the unemployment. Go to the Texas Workforce Commission and get their unemployment benefits.
Right.
And there's some criteria to that too, because when you file for it, they're going to see if you were wrongfully terminated or if you caused it, and how long you've worked there. I think you have to be there 6 months, and I can't remember exact the terms right now. We'll give you some websites to look at that so you can go see if you qualify. But that's kind of you should mitigate. I mean, everybody should work. You shouldn't be a deadbeat just relying on the government dole because you got a job and oh boy, now I've gotten fired, so now I'm going to get unemployment. A lot of people do that. It's really aggravating.
Right.
But most people don't. Most people have the integrity to want to work and to be good and to show, just like God wants us to do, to come in and do the best that we can, be the best person we can be. But sometimes that, from an economic standpoint, you can't do that because you can't find a replacement job.
But what I'm talking about is it ruins your claim against your previous
Yeah.
employer who fired you
Yeah.
because you sat home for 6 months
Well,
and done nothing.
Also, to get unemployment benefits, my understanding is that you have to actually be looking for a job. You've got to prove
Right.
that, just like when my clients are on probation. Let me take that back. It's not probation. Probation, they have to look for work and they have to show they've looked for it. It's mostly when I have clients that have child support that's due. And usually if they haven't paid it and they've showed up at that little hearing where it's really just you talking to the assistant, the attorney general's assistants that are working there, their attorneys, they'll usually make a deal with you where if you haven't paid your child support because you can't afford it, then you've got to show that you're looking for work. And I'll always get these people saying, well, I haven't, I've been looking. And they really haven't until they get thrown in jail. And they will, if they haven't been literally significantly looking for work at least 3 times a week legitimately, then they'll be in jail. And that kind of shows them the lay of the land. And it does happen too. But
it shows the person who's been thrown in jail the lay of the land.
yeah, because they're thinking, oh, well, I'm just going to show them. I've looked at the internet. And because they're mad at their ex, they don't want to give
Right.
their ex money.
Sure.
And so they're intentionally not working.
Yeah.
And that always shows up. So if people just do the right thing, as we're taught in Bible school and the Bible and everything, if you just,
And your own conscience tells
in your
you
conscience,
that.
if you just do the right thing and you don't have hard feelings and you're not doing it because you've got anxiety, if you forgive those that trespass against you for whatever reason that you're not working, if you go forward and just do the right thing, everything will turn out for you if you just be the best person you can be. But a lot of people are unhappy because I took this job and I've been fired.
Yeah.
And to damages, the little spill about damages is employees must show that they suffered some type of harm due to termination. The type of harm is often economic in nature. And if an employer breaches the employment contract, courts are reluctant to order one party to do what it said it would do. Courts are more likely to make an employer pay an employee financial compensation that the employee directly lost as a result of the breach. And the reason I'm even saying that is because people will not work to show that they have more economic harm. But you can't do that. You've got to mitigate, just like you were saying. You've got to go out and look. And more than likely, if that job didn't work out, it was because it wasn't supposed to work out.
Right.
So you can go find where you're supposed to be
Yeah.
and look at it as a benefit and not have hard feelings.
And I think what Tony's saying too is that a court is not going to order your ex-employer to hire you back.
Yeah.
What they're going to do is say, okay, pay them the money that they lost.
Right. But you're not
due
going to
your
get it unless you can
termination.
prove that you tried to mitigate it. Kind of all is
Right.
the same ball of wax.
Right.
Mhm.
Okay, well, so let's move on to wrongful termination based on discrimination.
Big
So
one, real
that
big
was
one.
breach of
Mhm.
contract. Yeah, we get Tony. I get this one a lot based on discrimination.
And just the big caveat on that is you can't say they discriminated against me when you've actually done something that was in breach of your contract or you
Right.
didn't do your work. You can't sit back at your job and be, doing nothing and then say, oh, well, I'm old and I'm a female or I'm pregnant or whatever the discriminatory thing may be. and so they can't fire me when you're really breached something else. So people, everybody that's called me, if you have a discrimination issue, you better not have breached the other side, the more, the contractual one, because
Right.
it's hard to prove discrimination.
Yeah, it sure is. Okay. So the elements for that is you have to show that you're a member of a protected class.
And this is federal and state law prohibiting this. And Texas pretty much aligns with federal. I think we've got two extra prongs, two extra elements that you can fight in Texas. So we're more broad for discrimination, but just these are actually ones that you can look up and we'll give you the website that are specific to discrimination. Okay.
Okay. So you have to be a protected class.
And what does that mean?
Well, it means that the employment relationship is considered a protected relationship. Both state and federal law prohibit discrimination in the employment contract, any kind of discrimination based on.
And that means you're a protected class because you're either women or you're of all the you have you're pregnant.
It's ethnicity, it's
Sex,
religion.
Right. That's all a big umbrella protected class. So first you're in the protected class because the company can't fire you because of age, citizenship status, meaning that you're not, they shouldn't be hiring you. They have to check that's another thing. They can't be
Right.
hiring you if you don't have your Social Security because they will now get the federal people will come after them. But that's a different story. If they can hire you if you've got a visa and you're allowed to work. Color, disability, genetic information, national origin, pregnancy, race, religion, or sex. Those are all the umbrella of protected classes. Okay.
Yeah, but there's a hierarchy in that too.
Yes.
So you've got ethnicity, you've got a race. I'm not even sure religion is right up at the top, but I do know that it's
not, but it's important because you can't say I'm not going to hire you because you're Jewish. They
Well,
all are.
we're not
equally-
talking about hiring. We're talking about terminating.
Right.
And so the problem and the question that I get a lot, and I know you got this last week,
Mhm.
was age.
Mhm.
So age is not way up there. And so what?
Well, no, they're all equal, but age is a hard one to prove.
Yeah.
Because it's an at-will state, and it could be that you can't do the job they hired you to do, and so you've reached your end of the bargain.
That's a really good point. Age is a hard one to prove, but ethnicity and race is not.
It's not, and so they use those are
Right.
the fallback ones all the time.
I see.
But it really,
Okay.
if an employer hires you, and I've been an employer and I've been an employee, to do a job and you can't do it because of your age or because of
and
your
we're at will.
or if you're because you're pregnant, they
Mhm.
can't. And let's say you lied and you didn't tell them you were pregnant, you can't not tell them you're pregnant and then turn around and you're gonna have a baby a week later.
Yeah.
And
It happens.
and I got hired. My story is I got hired 8 months pregnant, and the guy that hired me did not know I was pregnant, and
Oh
I
my
didn't tell him
gosh.
I was pregnant.
Yeah.
But I was a really good deal. I was getting paid way under, and I was honest with him. And if he wanted to fire me, he could.
Right.
I wanted the job, and I did a great job. I worked there for 12 years, and I told them I was going to need a little time off for my maternity leave, like a month later, and they were stunned. They wanted to fire me, and I said, "Well, I can work from home." This is before we had all the computers and all that stuff working
Right.
from home. And I said, "I'm only going to take a week of maternity leave," which I did. I had the baby. I had my daughter, Brooke. And I literally was up and going the next day. And I went back to work the next week. And I hated leaving my baby. I really hated it. And they gave me, a little leeway where I could bring up a stroller and I could breastfeed and all that stuff. But I didn't let them down. I held true to, I needed a job. I needed the money. I was what they needed. So that doesn't always fall into place. You're not going to get fired because you're pregnant, but you should be honest. I thought for sure
Absolutely.
they thought that I was pregnant. I was ready to pop.
Well, you're a skinny little thing. but
I had a jacket on and I was an avid skater. And so I didn't look that pregnant. I was able
Wow.
to cover it.
and she was your first?
She was my
Try-
second. I
okay,
was just
try.
in such good shape. But
Yeah.
that's near nor there. I wasn't being dishonest not telling I was pregnant. They just never asked.
Okay. All right. So you got to prove for discrimination protected class that you're a qualified employee,
Mhm.
qualified for the position,
Yes.
that the employee was terminated from their position. How hard can that be? Either you were terminated or you weren't.
And it has to be that they were terminated in this scenario because it was based on them being in a protected class. And it says there are various ways that employees can demonstrate that this discriminatory motive, including statements, statistics, or even company policies that were biased against the protected class. So there's ways you can prove it.
They can't claim wrongful termination if they quit the position before being terminated.
Yes.
In some situations, an employer might force an employee to resign which can constitute a constructive discharge.
Right. Because all games, and we all know the little games that happened in or the workplace.
Right.
They can kind of force you into it by
Mhm.
making you so miserable
Yeah.
that you want to quit. That's constructive termination. They can't do that. But if you up and quit and then say you're fired, and that don't work. You can't do
Right.
that.
Okay, and then there are influential factors. So I think what we were talking about you terminated from your position, a qualified employee, it's all evidentiary factors. You
Right.
got to get together with an attorney
It
and
has
you
to be legitimate.
yeah,
Mhm.
yeah. And then you argue, well, we can prove that they were terminated because of their protective status based on statements they've made in the
Mhm.
past, based on statistics.
Mhm.
The company always fires people that are 45 years old and Hispanic and I don't know what.
Yeah, they normally do
Yeah.
that.
So influential factors. Courts weigh a variety of factors in determining whether wrongful termination occurred due to discrimination. We
Right.
just talked about
Right, and
a lot of those
I'm going to
factors.
give an example of a case that I did, and we won. But go ahead, I want to hear more about the factors.
Let's see. Some of them include whether the employee was given a reason for termination,
Mm-hmm.
if an employer's discrimination is well documented
Mm-hmm.
by the factors we just talked about,
Mm-hmm.
whether a legitimate, non-discriminatory reason was given for the employee's termination.
Mm-hmm.
I mean, that will trump. And even if
Yeah.
they're being discriminated
Mhm.
against, the employer will, if they're not
Yeah.
dumb,
Yeah.
will give them a legitimate,
Right.
non-discriminatory
Mhm.
reason. And if the employee worked to minimize the extent of any financial harm,
Right,
that's what we're
mitigation.
talking about,
Mhm.
mitigation.
So,
So-
the bottom line with all of this is you have to truly have been wrongfully terminated. This can't be I'm mad I was terminated,
Right.
or I'm going to hold my breath. I don't want to do that. If you're hired in a hospital and one of the first things they give you is cleaning bedpans, and I just got out of medical school. Why are they doing this to me? I don't want to do this. Well, more than likely, a doctor is not going to be cleaning bedpans. But if they did, I mean, you have to have the grace, that of Mary. You have to do what you were told to do because it may be a test to see if you're willing to do the lowly things before you're promoted. So we all have those tests and what have you. But if you're wrongfully terminated, and a lot of people are wrongfully terminated,
Right.
then you need to look at these things and weigh these different factors.
And another piece of evidence is that if another employee who is not from a protected class was not terminated
Right.
and did the same thing.
People know whether they're wrongfully terminated or not. They have an
Yeah.
idea.
Yeah,
Mhm.
they sure do. Okay. So our next topic is going to be wrongful termination based on retaliation.
That is a big one.
It
I hear
is.
it all the time.
Yeah.
And this goes on the level of the lower level employee that has somebody next to them that they're working with that's competing with them. This happens a lot in very competitive, like with companies that are large, like say Facebook, large companies where people are all working. They have thousands and thousands of employees. Where people are, they're clawing their way up
Climbing
to the
the
top,
ladder, yeah.
and they're willing to throw their coworker under the bus to get the promotion or to take to get credit for what they've done. And I hear this not a lot, but enough that it's significant. Where one of the not just higher level retaliation, like you're turning them into the government, but where somebody has tried to get you and they're lying to the supervisor that you have in common, so that you will get fired because they were going to fire somebody and they want you to look bad. So that almost kind of falls under a retaliatory deal, where if you're fired because someone's lied about you, but it happens, and that's really difficult. You just have to watch your back. That's the best thing I can say, is watch your back and do the best job you can. Don't let somebody get you in trouble because they want to get rid of you. And people do that. They're bad. There's evil everywhere.
Okay, well, we're going to take a quick break. And when we come back, we are going to pick up the topic wrongful termination based on retaliation. Tony and Cheryl, we're talking about employment law today. We'll be right back.
The Texas A&M AgriLife Extension Service has been dedicated to educating Texans for over a century. In 1915, the Extension Program was established under the federal Smith-Lever Act to deliver university knowledge and agricultural research findings directly to the people. Ever since, AgriLife Extension programs have addressed the emerging issues of the day, serving diverse populations across the state. Texans turn to Extension for solutions in horticulture, agriculture, 4-H and youth, and family and consumer sciences. Extension agents respond not only with answers, but also with resources and services that result in significant returns on investment to boost the economy. Join us Fridays at 1 o'clock for the AgriLife Extension Hour.
Health Center Southeast Texas is a federally qualified health center. We accept Medicare, Medicaid, and most major private insurances. For our self-pay patients, we have a sliding scale discount program available. Our health centers have qualified providers and staff striving every day to provide the best quality of care to our patients. Services offered are family medicine, behavioral health services, telepsychiatry, and pediatrics. We have 4 area locations. Look up the Health Center Southeast Texas online at hcset.com.
A Lone Star Community Radio is Montgomery County's radio station with talk, music, weather, and traffic for Montgomery County. Have a question or comment about one of our shows? Want to know how to reach a host? Just contact the station at irlonestar.com or call in and leave a message at 936-647-3776. Get involved with your community with Lone Star Community Radio.
Welcome back to the Legal Connection with Tony and Cheryl. Today we are talking about employment law, and we've been on the topic of wrongful termination. Right before the break, we were talking about wrongful termination based on retaliation, and I think that you really made a good point, Tony. There are really 2 prongs to that. One is what you called higher level.
When you report to the government
Yeah.
when they've done something that's wrong.
Your
like
employer.
They're dumping, the ones you always hear about, they're dumping, waste, and I'm being told to do it, and I know it's wrong, and I will
Right.
be the one that's going to hold it. And so you have to report them, and you're being
Right.
fired because of retaliation. But the more common one, and the one you don't hear about so much, is when when you have lower level management and people even below them that are fighting for the same to get higher in the hierarchy of the plan and to get bonuses and what have you. They'll see somebody that's on their level doing something wrong, and it may come back to hurt you because the management may align with the lower level
When you complain,
when you complain because
They
they're better
say-
friends, and it's really sad because it's because of who they know and not what they're doing. So you just have to be really careful. And I know it's really stressful, and that's why we pretty much work for ourselves. It makes you want to go out and actually better yourself and get and be your own boss. But on the flip side of that is you've got the same, sort of. There's a different difficulty, and that's making sure that you are responsible and you work for yourself and you go out and so you're doing everything. You're getting your
right?
so there's different stressors.
Mhm.
And that's when I just go to mass and
Right.
ask God to take on.
Right. A
you know,
friend
the
of mine, an attorney, was in with a big group and some really high profile people. And he finally just quit and went on his own because the paralegals for the attorneys that had been there forever, the big, powerful attorneys and stuff, were setting him up.
Yes,
And
the first
filing
job I
stuff.
had, I was set up by the paralegals. I didn't even know it. I was so green to it. I'm
Right.
like, they were like, they would be so nice to me, and they'd be like, "Oh, have you done this? And can you do this?" But then they were talking down to me, and I thought this is really odd. because
Yeah.
I've been a landman for 30 years, and I've done this stuff. I've managed 40 people at large corporations, so I understand what needs to be done. But they were talking to me like I was just an autistic idiot, which I am
you're
to some
not.
degree. I think I think I've got some degree of Asperger's, but a very high functioning one. I like to think of myself as Rain Man, counting those sticks right as they fall.
Einstein. Right.
But
right.
did you read in the paper? Speaking of, I'm just going to do a little off thing. I read where I don't think there's papers anymore. It's on the internet.
No, I read the paper this last weekend.
Wow. Okay, because I always give I'll give money to the guys that sell the papers because they're working so hard. I don't know that much. But I read where a law firm in Atlanta hired, they were the first in the country to hire an openly autistic lawyer. She had passed the bar in Florida. So gone to law school, got it, passed the bar. And she was autistic, but a high functioning autistic, and they just loved her. And I thought, and they said, we really want to show people that autistic people are not what you think. They're
Right.
high functioning ones are brilliant,
Right.
and you need to let them do what they do best and give them a chance. Like
Right.
you should give everybody a chance.
Sure.
And it's almost a discriminatory thing. You think they can't do it, you don't give them a chance. And I saw this girl, and she was being sworn in. She's beautiful,
Yeah.
but I don't think that had anything to do with it.
Right.
But anyway, so that kind of went toward high functioning autistic people like Rain Man, he did the card counting. We just watched that movie. Jim and I are watching the 100 top movies ever,
Oh,
rated by.
wow.
We are having so much fun.
Oh,
Every
I
day
bet.
we watch one or two. We just watched Citizen Kane.
Oh, yeah.
Oh my gosh, I love that
What a
movie.
great
It's the thing that we
movie.
had not seen. And last night we watched Giant, all about Texas
Yes,
and Jet
I
Rink.
know.
We are loving these
Elizabeth
movies
Taylor
right now.
and
Yeah, when, in
Rock
her heyday.
Hudson. Oh,
Loving it.
I
Rock
know.
Hudson, yeah.
Okay, well, so listen, back on to
Yes.
based on retaliation.
Mhm.
So there are two prongs. It's complaining to the government, but also being retaliated against because you complained about something that was going on with a
Mhm.
colleague or something like
A vertical, not a horizontal.
that. Right. So to win a retaliation case,
I'm
a
sorry,
party-
horizontal's not vertical. Got it mixed up.
Yeah,
Vertical's up
right,
again.
right, right. Okay, to win a retaliation case, a party must successfully establish the following elements.
Mhm.
Okay, that there was a protected activity.
Mhm.
You must have engaged in a protected legal activity or exercised a protected legal right.
Mhm.
Like my company's asking me to supervise the dumping of toxic waste into the river, and I can't do it, and so I'm going to tell. That's a protected legal right.
And the
that you have.
example they give in our printouts is when an employee refuses to comply with an employer's request to participate in an employer's discriminatory activity. That would be if you were hiring people and they said you can't hire people under these discriminatory reasons. Another example occurs when an employee participates in an investigation regarding an employer's illegal conduct. And that's the big one you always read about hazardous waste dumps. And that kind of
Right,
thing.
right. Okay, and then the
second prong is-
thing is that you were fired due to that activity.
Mm-hmm.
Okay, you weren't fired because you never showed up to work on time.
Mhm.
You weren't fired because you called in sick every other day. You were fired because you actually made that phone call
Right.
to the authorities.
But it's up to you to prove it. You have to have direct evidence, including written or verbal statements, while the circumstances of evidence is based off of an inference that a termination was due to an employee exercising a legal right. Employers often respond to retaliation claims by arguing that a valid reason existed for the employee's termination. That's why, while it's happening, you need to be quietly keeping track, because I think we've all watched the Pelican Brief. If we haven't, the bottom line is if they see that you're watching what they're doing and they're going to tell, they could physically hurt you, not just harm because they're doing something wrong, and their livelihood's
Right.
in trouble. So be really careful when this kind of thing happens.
And also make sure that you're showing up to work on
Yes.
time. And that
But do your
you're-
job.
Yeah.
But if you see something's wrong, it could be, though, they're not doing something discriminatory. So keep track, but just watch. Be like the Indian. Be quiet. Walk softly, cover the big stick. Your
Mhm.
big stick is keeping the evidence and not talking to everybody in the world. Remember, gossip is not
Yes,
good.
yes.
The water cooler stuff doesn't work because that's also going to get you fired. So just do your job. And if you see something that you think might not be right, kind of quietly keep track of it to yourself and keep your evidence, because your instinct may be right.
Mhm. And then you have to show damages have occurred, and we've covered that in other
Right.
things. They're economic,
Mhm.
lost income, things like that, lost health insurance, lost whatever you lose there.
Mhm.
Wrongful termination based on harassment.
Mhm.
Harassment by an employer can include many types of behaviors, exclusion from meetings, information, applying double standards to employees. We just talked about that.
Mhm.
That's an aspect of wrongful termination by retaliation.
Mhm.
Sexual harassment.
We hear
know-
that. That's such a buzzword right now, is sexual harassment, like this guy, that producer that just got ousted. and
Weinstein.
And that's a big, that one I kind of go both ways with, because I can see where these people knew what they were getting into, because historically, if you want to get in the movies, you're going to like schmooze up and, do what you have to do to get the job.
Well, that's how we were raised. We always knew that it worked that way, even though
Right.
we hated it.
And-
And it made a lot of those actors and actresses just instantly lose respect.
Right, because they knew that that's what we're doing. And a lot of them did get their jobs without having to do that,
Yeah.
okay? So on the one turn, they kind of knew what they were getting into, and they don't have to buy into it. They could just say, I know I'm the best person for this position or this particular, acting, I don't know, what do they call it? Role, thank you.
Mhm,
You're an actress. On the other hand, they really shouldn't be doing that. So it depends on the degree and if it's something in the industry. Certainly, if you're being sexually harassed, and we've seen all kind of shows about this, because I don't have any that I've actually done. I've done a case on sexual harassment. If you're being harassed and somebody is, coming after you and visiting your house and leaving you notes and bringing your flowers and it's unwanted and that kind of thing, clearly that's kind of that's
Yes,
crossing the
constructive.
line.
I have a client that went through the same thing. Beautiful, beautiful young woman. and she worked at a spa in
Mm-hmm.
a part of Texas. And one of the owners of the spa was a guy, and then his ex-wife was the other owner.
Mhm.
And the guy was calling her constantly, showing up
Mhm.
to her house, pinning her against the wall
Mm.
at the salon, at
Mhm.
the spa,
Mhm.
and she had to quit.
Mhm.
And I love this because it says constructive. If you treat an employee like that, that can be seen as constructive termination,
Mhm.
and it's the equivalent of wrongful termination, even though the employee has quit on their own.
Right. They're like, oh no, look how much everyone sees them getting flowers and special treatment. That's really not the case at all. It's crossed the line into craziness.
Right.
So yeah, that I almost see when I see this kind of thing happen because this is so egregious. Just leave.
Yeah.
Just I would think that if you're a really good employee, and particularly right now with the climate that we have in Texas, with
Right
how well
now.
our economy is in Texas, with building the wall, particularly is going to make our economy better. We're just booming right now down here. So when I see people, when I hear people saying I can't find work, it's like, oh no, Home Depot's hiring, Kentucky Fried Chicken. It may not be what you want, but it's a job that's going to pay you at least. I think minimum wage is like $10 an hour now. I don't even know what it is, but
I don't
but
think
I
it's
know
that
they
high.
are all paying $10 an hour.
Right.
Okay? That may be a little bit over minimum wage, and so you can find work. And if you get in there and you work really hard and you do a good job, you'll be promoted. And so I hate when I see people coming out of college saying, "I'm not going to take that job." No, you should go get the experience and take the job.
But and say like in this case with this client I was telling you about,
Mhm.
she at this particular place that she worked at, she made $3,500 a month. She had to
Wow.
quit
Mhm.
and couldn't find anything
yeah,
that could,
yeah.
and so she took 2 part-time jobs.
Well, maybe it's because they knew that they were going to have to pay her to stay because they had this kind of weird person working there that
Uh,
harassed.
Well, he was a freak and
What happened though? What did she end up doing?
well, and I think this would be a good segue into our EEOC thing.
Uh-huh.
She contacted the EEOC. I was telling her to do that. She contacted them. There weren't enough employees in the business
Uh-huh.
for the EEOC to take it up. So she still had a private
So it's less
cause
than
of
15,
action.
I think is what it is.
Less than
Mhm.
15 in that, even though they had, I believe, 2 or 3 different locations,
Mhm.
the employees traveled
Mhm.
back and forth between the locations.
Mhm.
I
And
mean,
then the
this is-
contract doesn't count. So it's really difficult when you have those small companies and that's really prevalent in the small companies when they're
What,
right at
sexual
about 10 to
harassment?
15, any kind of wrongdoing because they're usually small and they have maybe 12 stationary workers that are
Right.
employees. And then they have a ton of contract employees,
Right.
which prevents them from being
Right.
subject to the federal and state discriminatory actions. So that's a problem.
Okay, Tony. Well, listen, we've got probably 10 more minutes here. Okay, we've got 15 more minutes. I think that might be a good segue for us to talk about what do you do if you feel like you've been terminated.
Yeah, but you didn't finish your story about the girl. What happened to her?
Well, so what happened was the EOC. So there's a
Uh-huh.
timeline,
Uh-huh.
and that's what we're going to talk about in a little bit. There's a timeline that you need to complain to the EOC, and the EOC stands for Equal Employment
Equal Employment-
Opportunity Commission.
Yeah, something like that.
Yeah.
I never can remember
Yeah.
what it stands for.
And if they're interested in taking up your claim, then they'll let you know you've got 30 to 60 days. I can't remember, but as soon as you get that letter from them,
You have to file to get the. It's called a. I can't remember this. I've done a ton of these cases. It's. It basically is a letter that's saying that you can sue. We
Yeah.
are not going to take.
you have
the
to get
case.
permission from them
and
that
it's called a
you can
letter of not
pursue
suing.
this
or whatever.
on your
I can't
own.
remember the name of it, folks.
I don't remember. What
I
the
don't
name
remember,
of it
but
is
it's the
either,
letter
but
that
it's
you
a
get
letter.
after you apply, after you file a complaint with the EEOC.
Mhm.
And just in case we don't get to it, you can Google them or you can call 1-800-669-4000 in Texas and I don't know where it's going to fall in Texas, but that's where you can go to file it to make the complaint. You can also file a charge. These are charges. You're making a complaint with the Texas Workforce Commission. You can do that online or you can call 888-452-4778. That's in Austin. Or you can begin your charge process with the NLRB, and I think that's the National Labor Relations Board. And that number is 866-667-6572. Usually, one set is Texas and the other state is federal, and you have different time frames on when you can file it, but don't wait too long. The National Labor Relations Board requires that within 180 days of being discriminated against, you have to file a complaint. So even if you're still working, federal employees must file a report of discrimination to the employee's equal employment opportunity counselor within 45 days of being discriminated against. So this is not even you being fired. This is you making a complaint after it happened. The problem is once you make that complaint, you're probably going to get fired.
Yeah. Or be forced out, because who can work under those conditions?
Yeah, because now you're that person that you can't be associated with the other employees. So you're now in a sort of a lonely existence while you're getting paid, and that's no fun. So you really have to have everything lined up before you make these calls, but you can't wait either. So it's a tedious little tightrope.
It really is. And that's exactly what happened with this client. We complained to the EOC. They notified her that they were not interested because the number of employees weren't over 15 in the business. So then we had to bring a private cause of action, not private.
So she
but
got
just-
that letter within like 30 days. It
She
said,
got
we're
the
not
letter.
we're not going to file. We're not interested. And so now you can sue.
Yeah.
The right to sue letter. Thank you. That's what it's called.
Yes. Yeah, right.
Mhm.
And so she didn't want to pursue it.
Mhm.
And then every once in a while, she'd kind of
She
waffle.
still work there?
No, she quit.
Okay, good.
She had to quit. And she suffered a lot of economic damages as a result of being forced out through that constructive termination thing. But she waffled.
Yeah, but what did she do before? What did she break it? Did she leave a job to go there?
Well, I mean, she did the same sort of thing.
Well, and so it seemed to me that she couldn't find. And I'm just talking out loud. Couldn't she find another job that was similar that just paid a little less?
That's what she did.
Okay.
But she had to find 2 jobs
Mhm.
because instantly she was out of work.
Yeah.
And she had,
And the same thing happens with
apartment
another guy that
payments.
called me. He left a job for the bait of a better job, and then they
Right.
duped him.
yeah,
And then the other company didn't want him back
yeah.
because he had duped them, or they
Wow.
felt like he wasn't loyal. And loyalty and integrity are huge because an employee-employee relationship is just like a personal relationship. So you got to really be careful. Okay, so what was the next? I stopped you. So I want to hear what happened to your friend.
Oh, well, it was a client.
Mhm.
And so she kind of waffled back and forth. She wanted to pursue it. She didn't. And I kept saying, we have this timeline. We've got a right to sue,
Mhm.
but we've got to do it within 30 days or 60
Mhm.
days. And so she didn't want to. Then she did. And then she had asked me about it 3 months later. And I was like, sweetheart,
Mhm,
listen,
mhm.
that's over. I told you very clearly.
Well,
So-
she could have still gone with the National Labor Relations Board, but I don't know what the criteria is for that.
It-
You have 180 days, but still, you've missed some of your opportunities when you wait too long.
It's
for sure.
really, really important. And she
Mhm.
had a really good claim too.
Mhm.
But it's really, really important that if you are the victim of some type of discrimination in the workplace or harassment,
Mhm.
that you timely call an attorney
Mhm.
that practices this kind of law, or
Mhm, mhm.
call the EOC and
Mhm.
ask them what you do.
And then don't completely, like we've had this show before too, don't completely rely on that attorney to pick up the ball and run. First of all, you may not have
Right.
hired him
yeah.
and you're losing time.
hmm
Secondly, they may malpractice, but what are you going to get if they don't have anything later to come back on? You've got to go through all this stuff to prove they malpractice, which is more attorney's fees. So
Yeah.
it's just not worth it. And it all kind of goes back to if this is not a good fit for you, you may just want to move on. And it may be discriminatory, but you better have a good case because these cases don't always pan out. But I will say this, the couple of cases that I have taken, one I did that was an age discrimination case. Gosh, it may have been 15 years ago. And it went to federal court. We ended up in the district court down in off of, I forgot what the street was in Houston. It was district court. And I forgot which judge we were, a federal judge. Really, really nice. You have to have your paperwork. You file it. You've got your right to sue letter. You go forward. You can choose whether you're going to file in state or federal, depending on which category it falls into. If you've got a discrimination case, it could fall into either one. State's a little bit easier, but sometimes even those companies move to have it in federal because they're more difficult to maneuver yourself around in federal court. It's just a higher level court, and they have different rules. So you have to get somebody that understands those rules. But I do remember going in, and he clearly had evidence of age discrimination. He worked for a large oil company. He got paid a lot of money, but he got fired when he was
How
like
old?
60. He was only
Okay.
60. I say only now because now 60 doesn't
Right.
seem that old.
Sure.
But and the age
Because it's
discrimination
not.
was not that big. It was like the difference between a 49-year-old and a 60-year-old. That's 11 years. But he saw that other people were being promoted over him,
hmm
and he said this isn't right. And so he had constructive termination because of what they were doing, and he wasn't getting promotions. And he was still doing a very good job. He had all the skill, he had all the background and the knowledge, he had all the education. There was no reason why he was being promoted over. And so we were able to prove that after we did the discovery, we took the case, we did it on a contingency.
Mhm.
We were able to prove the discovery that they consistently were getting rid of older people because the insurance was higher.
Oh, good for
And we got an
you.
amazing settlement without even having to go to trial.
Good.
We went to the pretrial conference, we went to mediation, and their attorneys, and they were a big corporation, were like, we're not going there. And they gave him a very large settlement because of age discrimination. It wasn't that big of a, so it's, again, you have to look at it, and it helps. I say it doesn't. It does help to at least run it by an attorney because they may have, particularly one that does a lot of employment law, to
Right.
see if they've got a case. You don't want to write it off, but they are hard cases to win.
And it's all won by the evidence and the
It's all by the evidence,
statistics
right.
that you gather about who they fired
he
over
did
this
tell
age
us.
and that age.
He told us that they're doing this not to me, but to a lot of people, and we were able to get the evidence. And it was just a matter of getting that evidence. And when they hide it too. We finally got it after our subpoenas and after motion to compel, and we got the evidence we needed. We were able to go through and go, wow, this is great, because we were just checking off the people that were terminated that because of age, and so it did work out. And it was only age, and didn't have anything to do with any of the other deal. But if you're a protected class and you are wrongfully terminated,
Mm-hmm.
or you are wrongfully treated in the
Constructively.
workplace,
Uh-huh.
then with the constructive termination, then if you have a case, go forward.
If you have a case, you can go forward.
Yeah, well, like we
Right.
did, we won.
Right.
So there's a lot of money in it, but you have to have somebody that's an employee that has the wherewithal to keep quiet, to collect the evidence, and
Right.
they've got a good contract. All these things have to fall into place.
Mm-hmm. Okay, well, we have wrongful termination based on a refusal to perform a criminal
Mhm.
act. I think we've kind of covered
Yeah,
that.
yeah, everybody knows that's all in the movies. I'm
Sure.
not going to do this.
Yeah, wrongful
You're
termination.
making me do it. I don't want to do it. I'm going to turn you in. You get fired. Those are great. I love those.
Right.
We had one example. It says in Texas court held that a car salesman was fired for refusing to misrepresent the trade-in value of a vehicle.
Oh,
As long as he can prove it, that's an amazing way. I mean, you're right there with a wrongful termination by refusing to do a criminal act.
mm-hmm.
Be able to prove it.
Mm-hmm. Wrongful termination based on violation of civil rights statutes. And under that, we have the Family and Medical Leave Act. We have military
Those are
leave.
so easy to
voting
prove,
leave.
though, that
Yeah.
you seldom get it. I mean, I'm just like, yes, military leave voting. I love it. But you don't get them very often because usually your employers know better.
Sure. That would just be kind of suicide,
Mhm.
you know?
That happens, though. They're not thinking. Got
Uh-huh.
some arrogant boss that's not thinking, and they're covering it. The higher levels don't know what he's doing, and then they find out. So
Uh-huh. Well, wrongful termination claims, they're not easy to prove, but as Tony and I have been discussing, they can be proven in Texas. And you just need to not lose your head, be cool, think
Mhm.
about, these things that we've discussed with you, and what is the best way to prove that.
now remember, when you have some of the strategies is first you have to write the demand letter. These letters
Mhm.
are sent to the employer describing the laws that are violated by the employer. And you usually want to, at that point, if you've got an attorney involved, they know what kind of letter. It's a cookie cutter letter for the most part. They know what to send. You have to file with the agency, file an agency claim. Don't forget to do that. In many situations, legal counsel must first file a complaint with the appropriate state or federal agencies, just like we were talking about.
Mhm.
And then only then after they deny the claim can you file a lawsuit, because otherwise the state or the government takes it for you,
Sure.
because and you'll still get compensation that way.
Right.
Litigation is complicated. The process, including several steps from filing an initial complaint to the trial itself, really does require, in most cases with employment law, an attorney to help you. Settlements can happen at any stage in the litigation process and can only be reached by settlement when all the parties are involved, not just you, but the employer also. Okay.
Mhm.
And the factors that the courts looked at are lost benefits, lost wages.
Mhm.
I mean, these are things that you're going to have to consider before you go forward.
Mhm.
And then the types of damages are
Compensatory.
compensatory, and
Oh,
those
it's one of
are-
those weird words.
Yeah,
you know?
It's like, I can't talk.
Compensatory.
Compensatory, economic. Well,
Uh-huh.
compensatory damages are designed to reimburse the employee for their out-of-pocket expenses,
Right.
do the discrimination, what have you,
Mhm.
loss of enjoyment of life, and that kind of thing. They're a little bit more difficult, and you don't always get so. But economic damages are really easy. They're the
Yeah,
primary
You
component.
always get those.
The emotional damage, really hard to prove those because
Mhm.
you're going to be emotional about it anyway. People are just sometimes very emotional, and they'll
But it depends on the facts. There's some things are just
and then
outrageous
they try
and
to show you're
egregious.
crazy, and they're like, "We had to fire her. She's crazy." You have to be really careful about
Well,
trying to
being
prove
raped in
those.
the workplace or something like that. I mean, you can get damages.
Oh yeah,
if it's
definitely. If
obvious.
it's something really, they've done something really
Yeah.
bad, and then punitive damages are difficult. But if they've done
Very
something really
difficult.
bad, these damages are designed to punish the employer for malicious and reckless discriminatory actions, and you can get them. And they give juries will give really big awards on those if they
Mhm.
see that you've been wrong because they can put themselves in your place.
Mm-hmm. Mm-hmm. I think it's interesting that in the year 2014, 888,778 discrimination charges were filed, and monetary relief from cases that were litigated totaled $22.5 million.
Yeah, but how many cases were taken?
Well, it said they were filed. It says, let's
I mean,
see,
in other words, how many right to
67
sue letters went out?
67% of employment cases result in favorable judgments for the employee. That's pretty
Really?
high.
That is huge. I'm
Mhm.
surprised. I did not know that statistic.
Yeah, that's pretty high.
Yeah, but that means that they've gone to the trouble of actually doing it because and we've
Exactly.
talked about this on our show before too. If you get into a lawsuit, particularly with somebody like a family member or an employer,
Mhm.
your life has now taken a turn for the worse because it
No.
absorbs your peace and your happiness. If you're
Right.
willing, but if you're willing to fight, just be ready because you're not going to have the peace that you had before.
Right. And so, if your situation is bad enough that you feel like,
You have to fight. For
yeah,
justice.
you have to fight. You can't not
May
fight.
bring you closer to the Lord. A lot of times it does
Yeah.
because you don't know where else to turn, and that may be part of His plan too.
Right. Right. So, interesting. The reason that we wanted to talk about this is because we get a lot of calls. I know I've got a call this afternoon
Mhm.
on a wrongful termination case
I
in
have several
Dallas.
calls that I have not returned yet,
Yeah.
where people have basically told me, they are people that have worked for a long time
Mhm.
at the where they've worked, and they've given me examples and facts that look like they're pretty good cases. But I've got to glean through them, and of course, we will take, we'll do free consultations, but
Yeah.
it takes. I got hit with like 10 this week, literally.
Really?
And if you're doing nothing but consultations, you're not getting any work done. So
Boy, that's true.
that-
And you're
so
not getting
people-
paid anyway. Oh, Tony, I had this question. So, in a wrongful termination suit, how would an attorney get paid? Would it be contingency? Based
all
on
the
a
ones I've done
settlement?
are contingency because these people don't have money because they've been fired.
Right.
They can pay you. I mean, they can do it any way you want. But contingency is pretty good with the large corporation. That's why I like the large corporations because then
Right.
the first thing you always do when you analyze a case is you're looking at, will you be able to be compensated? Are they judgment proof or not?
Right.
And-
And judgment proof means they can't afford to pay you anything.
Right.
So, in that case, leave it alone.
But large corporations are usually not judgment proof. And what we've seen also is that these small corporations will move all their stock. They'll take the assets and move them into a different corporation so you're not suing the right place because they're small enough. They're just over 15 people, so they can be sued, but they don't make themselves judgment proof. So they move the stock into a different company so they can't be sued. That's fraud. They can't do that, and it could be found in discovery. So don't worry about that much, but do keep track of it.
Okay. All right. Well, listen, guys, we are here every Tuesday from 12 to 1 p.m. You can listen on irlonestar.com or you can go to 104.5 and 106.1 Conroe's FM. You can send us your messages on Facebook Messenger, and we try to get back to those during the week if we can. And
But we do get back with everybody.
yeah, we appreciate all our listeners. We know there are a lot of you guys out there. Thank you for being interested in listening. And always remember,
Serve God by serving others.
have a great week.